This week's episode of the And She Looked Up podcast is brought to you by Fine Lime Illustrations. If you love quirky, colorful art transformed into fun, handmade stationery items, pretty much guaranteed to brighten somebody's day, that's just what you'll find in my new online shop at finelimeillustrations.com. That's fine as in I'm fine, lime as in the fruit, illustrations.com. Browse the entire collection or sign up for my email list to see some behind-the-scenes peeks into my studio. You'll also get first notice of new product launches and subscriber-only sales. And as an added little bonus, you'll also receive a free coloring sheet to help you relax and de-stress from your day. And now, on with the show. Welcome to the And She Looked Up podcast. Each week, we sit down with inspiring Canadian women who create for a living. We talk about their creative journeys and their best business tips, as well as the creative and business mindset issues all creative entrepreneurs struggle with. I'm your host, Melissa Hartfield, and after leaving a 20-year career in corporate retail, I've been happily self-employed for 12 years. I'm a graphic designer, an illustrator, and a multi-six-figure-a-year entrepreneur in the digital content space. This podcast is for the artists, the makers, and the creatives who want to find a way to make a living doing what they love. Hello, everyone, and welcome to another episode of the And She Looked Up podcast. As always, I am your host, Melissa, and this week I'm very excited because we are doing an episode that I've wanted to do for a very long time with a guest that I have wanted to have on the show for a very long time. My guest today is copyright lawyer Lesley Ellen Harris. Welcome, Lesley.
Oh, thank you, Melissa. It's a great podcast, and I feel honored to be part of it and hopefully help others and answer their questions.
I have a lot of questions for you today.
I like questions.
This is going to be fun. So for those of you who are not familiar with Lesley, she is a copyright lawyer and the founder and CEO of copyrightlaws.com. She is also a published author, a copyright blogger, and a highly respected and passionate copyright educator. Her areas of expertise include Canadian and U.S. copyright law, international copyright law, and licensing digital content. So that we might have some interesting questions around that. Having seen copyright from many perspectives, Lesley shares her knowledge and experience in her 10 books and through her in-person and online courses. Her greatest skill is simplifying copyright down to plain English, which is exactly what we want to do today.
Perfect.
So before we dive in too much, the first question I ask everyone who comes on the show, whether they're an artist or a creative or not, is, Lesley, did you feel like you were creative as a kid?
Yes, I actually do feel like I was a creative kid and hopefully a creative adult. Maybe not in the traditional sense that I can draw or paint, but I was always, really always on my bicycle, riding to the beading store or the wool store. I love to crochet and embroider and bead. And I also was a very creative bug collector. I'm surprised that I ended up in law, considering I love to collect caterpillars and watch them mine always turned into moths and not butterflies, and then let them free. And I actually wrote stories, like short stories as a kid, and was always asking my mother to try and get them published. So that's me in a nutshell.
Did your mom have the avenues to get them published, or was that just something you thought parents could do?
Well, I was a kid and I thought parents could do anything we ask, but no, my mom had no knowledge of the writing or publishing industry and no contacts. But she did, she and my dad did provide a creative environment for me and my siblings. So that's really what every kid wants and needs.
Absolutely. So how did you go from, because you mentioned you love to collect bugs. You could have become an
Yeah.
entomologist.
No, I thought I would. When I was little, I was much more science oriented. I mean, I had a microscope in my room, and I would take also bugs, which I probably killed, but we won't go there, and put them on the little slides and under the lens and just look at them. But I don't know, at some point I switched from science to much more humanities type of education, eventually leading me to law school.
And what made you decide to specialize in copyright law out of all the different types of law that you could?
Yeah. Good point. Well, that was very easy for me because by the time I went to law school, I decided I wanted to be a fiction writer. Oh. And I thought, okay, I'm going to learn everything I need to know about contracts, hopefully for a publishing contract, and copyright, and that whole area. Little did I know when I started law school, as none of us really knew with the internet and digital everything, what a large area of law I was studying, and would soon be able to apply these more traditional copyright principles to digital. So that was a very easy transition because as digital became popular, I was already working as a copyright lawyer. So I only had to jump in piece by piece. And there were, of course, a lot of unknowns at the time.
I was just going to say, because it always feels like as technology changes, the law is trying to catch up with it, especially in the copyright field. I feel like, there's been a huge buzz around a lot of these AI tools that have popped up recently, and a lot of questions around where the content comes from and things like that. We'll get into that later, but
yeah.
So I would imagine it is a constantly changing field of law to be practicing in.
Yeah, it does change, but I mean, the law itself changes very slowly. It's the application, and often the same, I'll call it old law, applies just fine to the new technology. And sometimes we have to wait to see how it works with AI, as we can talk about shortly.
Right.
But the Canadian Copyright Act, for instance, was written in 1921 and enacted in 1924. And it's that very same Copyright Act we have today, with now many smaller and some bigger amendments to the Act. So there are principles in the Copyright Act, such as fair dealing, which can apply to both creations in 1924 and creations in 2023.
So it's almost 100 years old.
Yeah,
I mean, big party for it next year.
Exactly. But as the government amends the law, less of it and less is the original, even though they've never overhauled it, as they've done, let's say, in the US and in the UK. It's been a more piecemeal approach, which doesn't really make it any easier for both lawyers and non-lawyers to piece everything together.
Yeah, it is definitely a field where, as an artist and a creative, I know that myself and so many of my peers and colleagues really struggle with is understanding what they can do and what they can't do. So I think this is going to be a really interesting conversation. But before we do that, do you still write by any chance? Like, you mentioned you wanted to be a fiction writer. Do you still do that in your spare time?
In my spare time, which is very limited these days and has been for years. But yes, once in a while, I'll write a short story, or even like jot down some notes for a short story.
That's awesome.
Yeah. What I do with that, I don't know. Oh, I did submit to the CBC short story contest. They have a contest every fall.
Yeah.
I actually wrote a story and edited and let it sit and had various people read it. So it's really in good shape. I submitted it. Of course, I didn't win, but it was a great feeling to get that short story to that point and just be part of that contest.
Oh, that's really awesome. Cool. Very cool
Yeah.
to hear that.
Yeah.
Okay, we're going to dive into my very long list of questions here.
Okay. I'm ready.
All right. So let's start out with the basics, because there's sort of three terms that get thrown around a lot in the creative world. And I think a lot of us aren't really sure how they're different, how they're the same. And that is intellectual property, or IP, as it's sometimes referred to, copyright, and trademark. So each of those is actually different. Is that right?
Yeah, that is correct. So you're ahead of many people already in your knowledge.
But how are they different? I guess that's the big question.
Okay, great question. And of course, necessary to start our discussions. Intellectual property consists of many different kinds of what we call intangible property. So that includes a patent, like the machinery behind your washing machine, a trademark, which could be a word like Kleenex or the Coca-Cola, the writing, the Coca-Cola logo, and copyright. And there are some other areas, but I'll just stick with those three for now. They're the best known. And copyright protects literary, artistic, dramatical, musical works, sound recordings, movies, just about all the content that we create and use, and sometimes use to create our own content, falls under copyright and copyright protection.
Okay. And so are the definitions of those different between Canada and the US, or are they fairly similar?
We could say they're somewhat similar, but they are different. Every country has its own Copyright Act, and each country defines similar kinds of work, the literary, dramatic, artistic, musical works in, let's say, in comparable ways. And there is a leading copyright convention called the Berne Convention, to which almost 200 countries belong, including Canada and the US. And just let me know if I'm jumping ahead, but this
No. So let's just clarify. It's not a convention in the type of convention that people go to a meeting. Like it's
no. Well, they did to discuss it and get it going. No, it's a treaty, like an international copyright treaty. And the treaties, even though almost 200 countries belong to the Berne Convention, each country has to interpret the convention and implement within their own copyright laws what they're including. And the obligations from the convention. But the most important thing, I think, for creative people to know is that once your work is protected in Canada, it's protected in almost 200 countries under the Berne Treaty.
Okay, so that is important to know.
Yes.
I think also one of the things I see a lot of is, you know what Facebook groups are like. Somebody asks a question, a legal question or an accounting question to the Facebook Hive, and you see a lot of different conversations coming up, and a lot of the people responding are from the US. And so I just wanted to know, like, is it important if you're in Canada and you're getting response from a primarily US focused group, is it important to recognize or realize that the advice, which I'm going to put in quotation marks, may not be exactly correct, I guess.
The same. Yeah, it may be different advice. I mean, first of all, you want to be careful getting any copyright advice online.
Yes, thank you.
You know, it's complicated. I always say it's complicated for non-lawyers. It's complicated for non-copyright lawyers. And sometimes it's even complicated for copyright lawyers. So sometimes it's hard to simplify the question or the issue. And it takes a lot more digging or asking other questions. And sometimes it means being practical. Sometimes, I guess, practical is a key response. But yes, I'd be very careful with any online advice and even articles you read online on copyright, because a lot of people, copyright lawyers included, have a perspective. So if you're in a copyright lawyer's blog, that blog may be more for educators or librarians who need to know about copyright law. And that blogger may be giving advice, quote, advice or information that may not be the most helpful for a creative person.
Right.
Oh, there is a lot of objective information out there too. You just want to be careful and really not to act upon all the advice you see, including, this is my chance to say, I'm not giving any legal advice or opinions in today's podcast either.
Exactly.
But I will try not to be biased. I'm usually pretty objective. But all that to say is a lot of copyright is about negotiating your rights, whether you're using someone else's content or someone wants to license your content.
Yes.
And sometimes you can get some good stories or information from different sites or in a chat group. So there definitely is a role for them.
Right. Okay. I think the biggest thing is just to be aware that there are differences between different countries, and that when you're on a platform like Facebook or something like that, very often the people who are responding are also not lawyers. So
yeah.
Just be cautious about the advice that you source from those kind of crowdsourcing platforms. So one question I do have is, and I can't remember if I put this on the list. I don't think I did, but I do just want to ask it quickly, is when you create a new work in Canada, is it automatically protected by copyright, or do you have to apply for copyright?
That is a great question and a key question to share. So the good news is it's automatically protected the moment your work is creative or in some sort of fixed form.
Okay.
So once you, let's say if it's text, once you write it down, or once you on pen and paper, or even write it down on tree bark, once it's saved on your phone or laptop or any device. So you don't have to do anything in Canada or in the almost 200 countries that belong to the Berne Convention.
Okay.
So once it's protected automatically in Canada, it's protected around the world.
Okay, that is good to know. Okay, so what does a trademark protect in our business? Like if most of us are small business owners who listen to the podcast, if we trademark our name or our logo, what does that protect? That's not copyright, right? That is protecting, like, I don't even know the words to use to explain that.
Yeah. So a trademark would protect a name. It could be a business name. It could be a name of a product or a work that you create. And it could be a logo. Now, a logo could actually be protected by both a trademark and by copyright.
Okay.
Which is good if you're trying to enforce your rights. You have two routes to go. And we'll get to that later on, how to protect your own works, or if you notice someone is using your works without permission. Trademarks in Canada can be registered. You register them with, I call it CIPO, Canadian Intellectual Property Office. It's good for 10 years, has to be renewed every 10. But you can also have what we call common law trademark protection, in which your use of the trademark, you obtain protection just by virtue of use. It's not as strong as registering the trademark, but sometimes it's sufficient.
Okay. And so if you trademark your name or your logo in Canada, is it trademarked in the US, or is that a separate process?
First of all, I'd have to, I'm not as
I know trademarking is not your area of expertise.
So I can, two things I want to say. First of all, I'm not sure you can trademark your own name. I'd have to look that up. But for trademarks, you'd have to register your trademark in each country where you want to use it. So it could potentially be a lot of work. But again, just by use in a certain region, or it could be a big region. I mean, using it online provides you with some protection.
I think that's the thing that is becoming more and more important to a lot of people, especially in the world of online selling and online marketing. You could be in Canada, but you could be selling to people, in Asia or Africa or Australia. And so it's just good to know where your trademark works, I guess.
Yeah, absolutely. And because there is some overlap, like I say, with the logo, copyright sometimes can be the easier route because you don't need to register it. So you don't have to take the time or the expense to register your copyrights, and you're still protected.
So one question that came up in a group that I was in, and this revolved actually around trademarking, but I just it was something I had never considered. It was somebody who was selling on Etsy, and she had a candle, and she used a particular phrase, a very common phrase, in the title of her candle. And she had a takedown notice from Etsy because apparently a very large bath and body company uses that same phrase in the title of one of their candles. And she was completely caught off guard by this because it's a phrase that just gets used all the time. And when she actually looked it up, they had trademarked that phrase for the purpose of candles, using on a candle. And so she was forced to take it down, and it caught everybody in the group very off guard because nobody would have even thought to look to see if that phrase was trademarked, because it's just something that's used all the time in regular conversation. So is that something that we need to be aware of as creatives, that things like a common phrase could be trademarked?
Well, if it's a common phrase, it's less likely to be an infringement. Mm-hmm. And a trademark only protects the copyright owner if a reasonable person, which hopefully you and I would be considered, would be confused with the origin of that mark.
Okay.
So, if someone uses a phrase with a candle and then someone uses it to sell, I don't know, aprons, I don't know why I said apron, then there'd probably be no confusion in that.
She was selling a candle, so it was a candle versus a candle. But
yeah. And it doesn't mean she would be liable for copyright infringement. Mm-hmm. But once you get a takedown notice, sadly, probably easier just to comply with it.
Right. All these little things that we just have to be aware can happen. Because she was shocked, and everybody who read her story was quite surprised too. But because you can look trademarks up on the internet and see who's got it trademarked and what they're trademarking it for, and there it was a registered trademark. So it was pretty crazy.
Yeah, it's a good idea if you're naming your products or creations to just Google the name and see what comes up.
Yeah, it's really interesting. I know back when I used to work in retail, like one of the things that I used to get a giggle out of is lipsticks. Lipsticks always have these crazy names for their shades. Revlon used to have this shade of lipstick back in the 90s that everyone wore. It was called Toast of New York, and things like that. And you would never really necessarily think that something like that could be trademarked, but I guess it can. So it's just, and everybody who bought that lipstick knew it was a Revlon lipstick. Like Revlon makes the Toast of New York shade. So it was, I guess in that sense, it was very much associated with Revlon. So yeah. Okay.
Oh, I just want to add to the automatic copyright protection, just take it a step further.
Sure.
You can register your works with the Canadian Copyright Office.
Okay.
It's a pretty simple form. And I don't know the exact fee because I haven't registered anything in a long time. And then if you do have an issue and someone's using your work without your permission, you can get a certified copy of that registration from the Canadian Copyright Office to help you prove that you created the work back, hopefully before, a long time ago, and registered it at that time, even though you can register it anytime. But your use and protection goes back further than the person who's using that same work without permission. Now, you do not register or submit or deposit a copy of the work in Canada. So many Canadians who are distributing and exploiting their works and on a commercial basis, they may register with the Canadian Copyright Office, but also register with the US Copyright Office, because the US Copyright Office requires a copy or deposit of the work as well.
Right.
So they're just really very helpful things if you have to prove your case. And the Canadian courts will give you a presumption that you're the owner of the work by virtue of that registration.
Okay, so for a lot of us who create a lot of stuff, like every time I create an illustration or every time somebody takes a photograph, I would imagine actually physically registering it is a pretty onerous process to do that for every single one. So under what circumstances would you recommend actually taking that extra step for something and actually registering it both in Canada and potentially the US?
Yeah, that's a great question. For instance, if you're publishing a book, you'd probably want to register. I mean, there's no strict guidelines on that. It's really more, do you think if your work is being used without your permission, you're going to pursue your rights and to the very end? Then having that proof and presumptions is a big help. But you can also, if you don't register your works, you can also register at the moment you see someone is using your work without your permission. So you don't lose out completely, but earlier is definitely better. And if you have bodies of work, like if you have 100 illustrations you create every month or every year, you can register those as a group. So one registration. So it's not as onerous as it may at first sound.
Just sounds like a lot of paperwork or digital work, and creatives aren't always very good at doing paperwork. So
yeah, I'll be honest, because I create tons of articles on my site, and I have course materials I've created and all that, and I don't register any of them, but of course they're all about copyright law, so I feel like I have that advantage. But definitely for my books, who I've had traditional publishers and association publishers, they always register those books.
Right. And that would make sense, because that's hopefully a very lucrative asset, right? So you would want to.
You would think, yes. We could talk about the value of intellectual property as well, because that's important to this audience.
But actually, you brought up your blog, and so there are a lot of bloggers who listen to this. So you could register the copyright of your actual blog, and would that include all the contents of the blog, even if you're adding new content to it after you register? Like, is that something you could do?
Well, you could register the individual work, so the photos and illustrations and articles, or I should say, or you can register your blog or website as a compilation.
Right.
However, that registration won't include future works.
Okay.
But then again, it's hard to know, because if you're not depositing a copy of the site or articles, like in Canada, it's hard to know what would be protected or not. So the other thing for all the website and blog people is including a copyright notice on your website. Some people add a notice at the end of every article. A lot of people have a link. It might say all that boring copyright stuff, or you can have fun with whatever you call that link. And in that page that it links to, you can say your works are protected by copyright, and to use the C in a circle, your name, and the year it was first published. So for a website, let's say if you've had it for 10 years, your copyright notice would be 2013-2023. And each year you'd update the current year. So 2013 to next year, 2024. So
Okay.
it covers that period of time. But an earlier date is important because it shows that your work was protected 10 years ago.
That's good to know because I see a lot of websites, and I think my own included. I'll have to go check, but we'll only have at the bottom, they'll have copyright and the current year, but they don't include the year that it began. So
Yeah,
like it'll just say copyright 2023.
Yeah, you definitely want to add that. And
Okay.
there's no requirements in the Canadian law. There used to be in the US, but they've changed that. So back to our Berne Convention, to be a member of the Berne Convention, you can't require registration or the use of a copyright notice.
Okay.
And copyright notices come in all sorts of sizes, shapes, and forms. And the best thing to do is just look at different sites, ones similar to your own, ones that are different, and see what they include.
Good to know. Okay, let's get into the actual process of creating. So when we're creating something new, what are we allowed to use when we create something new? So, and I feel like this is a huge question, especially in this era of sampling and remixing. Mm-hmm. But I'm coming at it more from like the perspective of, so when you walk down the aisle at, say, a local craft fair or scroll through your Facebook feed and you see people who, you know, they got a Cricut cutting machine for Christmas or they have a laser cutter, and you see them creating tree ornaments and t-shirts. Print on demand t-shirts are huge right now, using their favorite sports team logos or characters from movies or TV shows. And they're selling those. So they're not just using it for personal use. They're actually selling them at a market or online. Are we allowed to do that?
I'd say probably not. I say it like that because each specific circumstance can be different. Right. But let's take one example. You put Mickey Mouse on a t-shirt and sell it. I would never do that. I would never do anything with Disney because they are very careful. They must have an army of IP lawyers.
They must.
So whether it's a Disney trademark or a copyright, somehow they find everyone, including a nursery school or daycare, with some of their characters.
Yes. Okay. So this was one of the big questions that came out of the local artisan group that I'm part of. That was something they were very concerned about. And I am seeing more and more markets starting to put it right out there. Like if you want to sell at that market, you can't sell anything that might have copyright infringement. So is that something that if you run a market or you run a craft fair or something, are you in any way liable?
Yeah, you could be. Okay. I mean, generally in any infringement action, if it gets to the court stage and all the paperwork, everyone's going to be named. I'm very careful again because my website is on copyright law. So if I have, let's say, a guest blogger come on and they write an article and they send me a photo, I actually get permission from that author or guest writer to use their photo. And we put, this photo was created by John Doe and uses with permission.
Yes. So actually, Lesley and I have known each other for quite a long time. In my previous business, we did a lot of work where we were working with other writers and photographers, and Lesley educated me on what I can and can't use and how I can use things in the correct way with permission and with the correct citations and things like that. So I feel like I learned a lot from you in the digital content space, and I have Lesley's book. It's on my bookshelf. Canadian copyright law. So yes, and it's a very helpful book. But
it is a little outdated, I should say.
I don't know which edition I have.
Yeah, it's up to 4 editions now.
So yes,
it's not terribly out of date because the law goes back, as I said earlier, to 1924. But there are definitely some amendments, and then there was a huge amendment at the end of last year, and this is great for creative people, that Canada extended its duration of copyright protection from life plus 50 years now to life plus 70.
Yes. And I didn't even include that in my list of questions for you, but that is something that I think more and more people are starting to think about. First of all, your work is protected after you die, essentially, with that.
Yes.
Right. Or I guess if you live a very long life. Is it 50 years after you pass away, or is it 50 years after the creation, or 70 years now? Sorry.
So there's like a general rule and a lot of exceptions. So the general rule is 50 years, or now I'm saying 50. It's now 70 years after the author's death. Okay. And when I say author, the Canadian Copyright Act uses the term author for anyone who authors any kind of work, even if it's a musical work or a painting. That's just the generic word for the creator.
Okay. So that's really good to know. It's also important to know from an estate planning perspective, I would think as well, which I know more and more people. So back in the early food blogging days, which is how I first met Lesley, people were creating these blogs and we're not thinking about them from the perspective of them being like these long-term potential income generators. So, it was just something people were doing for fun. And as the years have passed and some of these websites have become huge and are earning healthy 6 and even 7-figure revenue every year, they start to think of them in a different way. It's like, well, this is a big body of work and it generates a lot of income for me. And what happens after I'm gone with that income? And so estate planning is starting to become more and more important. And so this is something that I think a lot of people just don't really know what to do with. Like, what happens after the 70 years? Does it just disappear? Can anybody use it? Or so I guess it's just something we don't tend to think that far in advance unless we're forced to.
It's a great question. So after 70 years after the author's death, that work goes into the public domain and anyone can use it as is, modify it, totally manipulate it. But let's just go back a second to what happens when an author passes away. Their intellectual property, so their copyrights and trademarks, maybe patents, all go to that person's heir, just like their physical property, their house, and I'd say laptop, but no one wants an old computer. And all their goods. So the physical and intangible property all passes on. However, many people who are in a creative business may want to actually have a separate type of will for a literary executor. So you may want to, when you pass away, for those 70 years in which your work is still protected, you may have one person in your life, or maybe more than one, because 70 is a long time, who then controls and owns your work. And they can license it to others. They can do everything that you're able to do with it.
Right. And so that, I suppose, could be really helpful if you wanted that property to continue generating income for your family or something like that after you've passed away. If you have somebody who's managing it for you to ensure that it's still income generating or not being used inappropriately or anything like that.
Yeah, exactly. And you see, well-known artists all the time who have been deceased for a while, and their estate, or it could even be a company, is now licensing all their works.
Right.
But that's important for everyone because some of it is licensing fees. You want certain people to benefit, but the other is just control over it. You want the right organizations or companies to be exploiting or distributing your work in a manner that would be consistent with your views.
Right. So, I guess if you are very anti-smoking, you don't want suddenly your artwork being used on, I don't know, a tobacco ad or something like that. So
exactly. Yeah, that's really important.
So can you also leave your body of work to like a charity or something that you want to be able to profit from after you're gone. Is that something that people can do?
You could do that. I mean, a lot of well-known artists will leave their copyrights to a museum.
Oh, that's interesting. I was thinking of, I seem to remember as a little kid reading that, was it James Barrie who wrote Peter Pan? He left the copyright to a children's hospital in London or something
Oh,
like that.
I didn't know that, but
Yeah,
that's so
I very
nice. What a
vaguely
great
remember that.
idea.
And I just thought, oh, that's kind of cool. So yeah, it is something to think about, particularly if you create a lot of works or content and it generates a lot of income, is what you'd like to have happen to that after
Yeah.
you're gone.
And you can also divide it up. Not that I want to create any more work for anyone, but if you have one particular, let's say, I don't know, painting or photograph
Right.
that is worth a lot and may support a great cause, you may want to just have an executor for that work and then an executor for the rest of your body of work.
Okay, good to know. The flip side of that, though, even though it's been extended from 50 to 70 years, in terms of talking about what we're allowed to use when we create something new, if something is in the public domain, are we able to use that within our artwork or written word or music or even a movie?
Yeah, great question. So yes, once the 70 years after the author's death has expired, the work falls into the public domain, and anyone can use that work in any manner they wish.
Okay. That's good to know. I see this with
Now,
Alice in Wonderland. I think Alice is very popular right now, and I see her getting used in all kinds of different ways, I guess, because I guess she's in the public domain, although I've seen Disney do stuff with her. So that's where it gets confusing to me, is if it's in the public domain, but then you have a big company like Disney making a movie from it or a cartoon or something like that. Is it still in the public domain, or how does that work?
Yeah, excellent question, and very important as a creator. If you're using what you think is public domain work, you want to make sure you're going to the source of that work, because if there's a new book or film out with the public domain work as the underlying work, the original public domain work is up for anyone to use, but any new works based on that have copyright protection, at least in the new parts of it. So take Romeo and Juliet. That's definitely in the public
domain.
Yeah, definitely. We all know that. But if you want to use part of that play, you want to make sure you're using the original work and not an adaptation of it, because that adaptation can have a new copyright in it.
Right. So in terms of something like Alice in Wonderland, where I see it being used is the illustrations from the original novel being used in a lot of artwork. So those would be the original illustrations. But if you were to use the Disney variation of what Alice looks like, that would still be copyrighted, I would assume.
Yeah, that would have a new copyright separate from the public domain one. And again, anything Disney, you have to be super careful.
Super careful. And I don't think people realize how big Disney is. It's not just Mickey Mouse anymore. Like, they own they own Star Wars. They own is it the Marvel universe, I think now? And so they own a lot of stuff. So it's not just Mickey Mouse at this point.
And their whole business is based on intellectual property. Yeah. So as much as we laugh like, oh, don't use their stuff, you'll get into trouble. That is their business. And that's really important for all of us too, to look at our creations. I mean, sometimes they're creations for us or our friends and family, but sometimes they're the basis of our business. Yeah. And so it's important to do everything we can to protect our own intellectual property.
Yeah. And I think this is something that comes up. I see a lot of people who will say something like, well, that's just a big brand being a bully. Like, I'm just a little artist selling baby Yoda pot holders. Like,
Right.
and they're making billions of dollars. Like, why are they coming after me? Like, they're just being petty, or they're being a bully, or they're doing it because they can, because they know I can't fight them in court. And yet the flip side is, if it was us and somebody was using our intellectual property to make money, we'd be very upset.
Exactly. And sometimes you have to think that way. Mm-hmm. So even though you may be frustrated by what you can't do, you have to understand why it's important for creators in general to protect their own intellectual property.
It is. And when you think about how many people Disney employs and how much they contribute to the economy, like, their whole business model is intellectual property, but they're generating a lot of economic movement through that, and that's important. So it's important that they protect it. Like, it's not always the big guy against the little guy, I guess.
Absolutely. And again, to emphasize that for our listeners, that everything you create is protected by copyright, and some may have more value than others, but to always approach your business, or even if it's a hobby, with that in mind, and to protect it from the beginning.
So before we get into what happens, like when you use things without permission, or when somebody uses your things without permission, one question that has come up a few times when I asked some people for a little feedback on what they'd like to hear, and this is when you use something that is licensed to create something new. So one of the big areas where this comes up is with fabric. So let's say you have purchased fabric that is properly licensed with a Canucks logo on it. So it's been licensed by the NHL, and the person who, or the company that is making the fabric, has the right licenses in place. It's all legit. And then you take that fabric and you make PJs or pot holders or whatever out of it. And then you sell those PJs and pot holders. Can you do that?
Well, good question. Really, you should go back to the manufacturer or whoever's printing the fabric, because they have a license, but that license doesn't go to you.
Right.
So you should be getting a license. I mean, if you make a pair of pajamas for your nephew and give your nephew those pajamas, that's fine.
Right.
But if it's part of your business or business model and you're giving them away or selling, because it doesn't always have to be selling to be distributing a work.
Oh, okay. That's good to know.
Then you should have a license from the Canucks or wherever the trademark or copyright originates from.
Right. I think that's a big area of confusion for a lot of people, because they feel like the fabric was licensed, so they're okay. But I guess if you're a creator or a crafter, or particularly if you do this as a hobby where maybe you're not thinking about it in the same way that others who are doing this as their sole business, it's easy to not even realize that these kinds of rules exist. But yeah, you may think you're doing everything okay because, well, the fabric's licensed, so I'm good to go. But essentially you're still benefiting off of somebody's intellectual property without permission, I guess would be the best way to describe it.
And to keep in mind that a license is a legal agreement or a contract, and that license for the fabric is between the original company or organization and the fabric maker.
Okay. So,
and that doesn't extend to what sometimes we call the end user or the creator,
right?
Taking that fabric. So that is tricky, and I could see why people don't understand that.
And if this isn't your business, if you just sell the pajamas or the pot holders at Christmas craft fairs once a year, it may not be something that you even think about. But I guess maybe a good rule of thumb for a lot of us is if it's not our logo or it's not our character, probably shouldn't use it, or err on the side of caution, maybe would be
Exactly. And a lot of places you can get permissions, like, for instance, comic strips. It's not that hard to get permission to use comic strips. Some places it may be expensive, but depending on the use, it may not be.
Well, this is a good point you bring up, is that you can always ask, right?
Exactly.
And a lot of people don't think to do that, but there is no harm in asking it. And the worst that could happen is the answer is no, right? Or you might have to pay some money to use it. But
yes. And then you can even negotiate if the content owner is saying, well, you have to pay, I don't know, $1,000 for your use. And you say, oh, I'm a small business person and this is what I do, and let them understand who you are. And they may have a different rate or be able to negotiate that rate. Right. So basically, don't take no or a high amount as your final answer.
Yeah, this is something photographers are very comfortable with. Photographs get licensed all the time for different kinds of usages. So
exactly.
So sometimes a photographer will say, yeah, you can use it. You don't have to pay anything. Just make sure you credit me. And other times, if you want it to be on a billboard in Times Square, they're probably going to want some money for that. So
yeah, exactly. And also, as a photographer, when you're licensing your works, you want to be very careful that the use you specify in your license is the only use they're making of your photo. I mean, that could be true with anything.
This happens a lot. Yeah.
Yeah. The photographers have been facing a lot of issues lately with that.
Yeah. A lot.
And it's hard to enforce your rights. I mean, there are mechanisms, takedown notices, and even associations will take a case on for you. There's free legal advice for artists. There's a clinic in Toronto, and I think one in Vancouver. And I'm not sure what other cities still have them. But there is lots of advice you can get out there, or help.
And I think this would be a good point to say it's also really important to read your contracts very often. And this is something I know when I left food blogging was becoming very, very prominent, that contracts that were being sent to bloggers where the brand wanted to use their recipe or their photo or whatever, very hidden down in those contracts. It would basically, the blogger was giving away all their rights to the use of the imagery.
Don't do that.
And so you want to make sure you read those contracts. And if you don't like what's in them, you need to speak up.
Absolutely. And ask anyone licensing your works for a simple contract in plain English. Yes. But you raise one of the biggest points that I wrote down a few notes before recording this. And my first note was, do not assign your rights. Generally, you just want to license them. An assignment means you're transferring ownership of your copyright. You generally never want to do that, maybe for the right price. But once it's out there and it's being assigned, you can't. But I guess you could ask for a reversal, but that would rarely happen.
Yeah, and I think a lot of people don't understand what it means when they assign their rights or grant ownership to somebody else. It means you can't use it anymore without asking the new owners for permission.
Exactly. Even on a digital resume, you can't use those works. You can't put it in a website to show others as your showcase.
So this is important for anyone who's I'm a graphic designer. And so when I finish something for a client, I do pass copyright to them, but it is written in all my contracts that I am allowed to use that for portfolio purposes. So on my website, on my social media, I don't own it, but I'm allowed to use screenshots or whatever so that I can still show that I did the work and that it's, part of my body of work, but I don't own it. I don't own the design. I don't own the...
That's a great idea to get the portfolio rights.
Exactly. So that's really important to understand. When you give up your rights, you are giving up your rights. It's not yours anymore. You don't get any say in what's done with it or how it's used or anything like that. And I think so many people don't understand that until until that moment they see it being used in a way where they're like, ah, no.
Exactly. Well, the good news in Canadian copyright law, we have what's called moral rights. And even if you assign your copyright to someone, you still have moral rights, which means you have the right to have your name associated with your work, or to use a pseudonym if you want to remain anonymous. And you still have the rights, even with an assignment, to have your work used as is and not to be modified in a way that may harm your reputation as a creator. And that could even be, it could be a manipulation use, or it could be use with a product, service, cause, or institution. So back to your example of a smoking or tobacco company, you still would have moral rights to prevent your use, its use.
That's really good to know. Okay.
Yeah. Now, just to add another layer of complexity, you can waive those rights. So no author would volunteer to waive them. But if you're asked by a licensee or an assignee to waive them, that would be a choice you'd have to make.
Right. And so in those instances, I would imagine you'd want to be very well compensated for that. So I'm just thinking about, I think it was at Bob Dylan, and I think a few other artists in recent years have, they're much older now, and they are actually selling their entire catalogs to large media companies. So Sony or whoever. And so in those instances, why would they do that? Like, to at this point in their career, to say, yeah, here you go, Sony Music or whoever, they're selling all the rights to their music and songs and lyrics and all of that. Why would they do that? Is that like an estate planning tactic?
Yeah, it could be. They may not have a copyright executor. They want who they think can make use of those rights and make more profits from them. And this way, it could all be set up for their heirs, and they could have income for a long time.
Right.
So that could be one reason. The interesting thing, I saw Bob Dylan recently sold his catalog. When he owned his copyrights, he was very much like Disney. And I always said, oh, don't even use like a single line quote from a Bob Dylan song. So it's interesting. He's probably very copyright savvy.
Yeah, I think he must have been. So I've seen more and more people doing that. He was one of the big ones, but there's been a few other really big recording artists and songwriters who have done the same in recent years. And I just wondered if it was a bit of a trend or.
Yeah, I've seen a lot too. I think it's just a choice, and like you say, part of estate planning.
Just nobody wants to deal with managing it, and so it's just better to have a financial settlement and invest that money in some other way or something like that, I guess.
Just a personal choice.
Yeah. Okay, let's get into what happens. Okay, let's say I inadvertently use something I'm not supposed to use. How can I get caught? Like, if I've used something without the correct permission.
Great question. You might never get caught depending how you use it. That doesn't make it legal if you're not caught. But I think anything you use online, there's a chance you could get caught. But again, it depends on the owner of that IP and how diligent they are. So bigger companies who make all their income is from their IP, they're going to have a whole plan in action to continuously comb the internet and look for infringing works. Now, often the first thing, if you are infringing someone's work, hopefully the first thing you'll hear is a polite, please take it down. Because it's mine sort of thing. You're not going to get what we call the nasty lawyer's note as the first communication. So that in general, you'll have to take some action. If you use some sort of infringing work, let's say in a printed book, that of course is not so easy to take down. So you want to be super careful in any sort of physical work, not
Right.
to have all your rights and permissions in place.
Now, in theory, if you're working with a traditional publisher, they're going to be on the ball with that. But a lot of authors are self-publishing these days, which means the onus is totally on them to make sure that they are not using something they're not supposed to use. And you make a good point. Once that book is printed, it's out there. So what happens in that situation? Like,
I know.
Does it get recalled like a car?
Well, no, I mean, there's always what's called an after the fact license, which sometimes can work, but depending on what you're using, that work can have a high value on it, which really you're not able to pay. So that becomes an issue, and maybe that's a negotiation as well.
So if you do get caught, and you can get caught in so many different instances. I know Etsy is
Etsy is having an issue now.
Etsy has many issues, but I think people who sell on Etsy, who sell things where it's a very obvious infringement, so like they're using Disney characters or things like that, Etsy tends to only remove things if the copyright holder lodges a complaint. So in that instance, yes, companies like Disney do comb through Etsy looking for things and will lodge a complaint. And then you'll get a notice from Etsy telling you have to take it down, or they'll just take it down for you. But Etsy has other things going on right now. They just had quite a scathing report about the fake stuff that's being sold, counterfeit goods that are being sold on Etsy and things like that. So, but you mentioned you may never get caught. And this is the thing, you could be selling something on Etsy, and unless that copyright holder lodges a complaint, you may never get contacted. You may continue selling that forever until somebody says something. But if they don't say anything, so it's not necessarily on, like, this is where I think people get confused. It's like, well, I got a notice saying I have to take this down, but here's this other person selling on Etsy, and they're using something they shouldn't be, and they haven't been told to take it down. So it's not, is Etsy not supposed to be policing this at all? Or is it just kind of like, no, that's not our job? I think that's where a lot of confusion comes up, is like, why did that person get a takedown, but I didn't, or whatever.
Yeah, there are various levels of complication and who's responsible for what, but there are mechanisms definitely for content owners to ask, let's say Etsy or Amazon or any of those, to ask a vendor to take that content down. But if you're in a business where you're creating and distributing intellectual property, you need to treat it as a business. So just like you'll have, let's say, all your financial records and accounting in order, you do need to consider copyright and trademark issues, and to make sure from day one, or if you're already doing something that is borderline, that you start cleaning that up and treat it that way. Because you could, as I just said, the content owner might ask you for an after the fact license for $100, but they might also say, no, it's worth $100,000.
Yes.
Especially if you've been selling it for a long time, or there's multiple copies, and it's harming the content owners making a living themselves.
And I have seen some photographers who have done this. When somebody has used their photos without permission, they'll send an invoice. Hey.
Yeah, that's a good way to do it too.
You use this is how much it would have cost you. You owe me $100 or $1,000 or whatever the case may be. So
yeah. And just back to photographers and others, when we were talking about contracts and licenses before, it is actually a good idea for you as the creator or author of these works to have your own license that you use all the time. So rather than waiting for another company to say, oh, we're going to send you our license. You just have your own that's straightforward, that is a license, not an assignment. And that way, all your licenses are uniform, and you don't have to have one sort of license from one organization, another from a different company.
You don't need a spreadsheet to manage all the differences.
Exactly. Just have it simple, because I think all the copyright and trademark issues can be overwhelming.
Yeah.
And anything you can do to simplify will just make it easier for you. So someone wants a photo or illustration, just send them your license.
Yeah, and it keeps you in control of the process as well, I think.
Exactly.
Yeah, which is always good to know. And you can negotiate that as well if they come back and say, well, that doesn't work for us, and they have a counter offer. So yeah, okay. So that's good to know. Let's flip this around. So, well, first of all, what happens if you do get caught? Let's say you get that polite note asking you to please remove it. What happens if you don't comply?
Well, if you do get a notice that there's an alleged infringement, let's say on your site, you want to investigate, because it may not be true. You have to look at that work and see if it's the exact same one that they're saying it is. Maybe it's a public domain version. Maybe it's not the same one at all. Maybe you even licensed it at some point, either directly from, let's say, a photographer, or you licensed something from one of the stock agencies. So every notice doesn't mean it's true. Now, that being said, what investigations can you do yourself, and when do you need the help of a lawyer? And once you need a lawyer, that changes everything, and it may be easier just to take it down. But there are many associations in Canada that have a lot of great resources for copyright and copyright infringement. So they're really good places to go to as a first stop. And again, one of the free legal advice services is a good idea to approach.
Okay. And that's very true. I've had takedown notices sent to me for photos that I have licensed through a stock company. And I was able, in all instances, I think it's happened about 3 times, I was able to show the license agreement that I had, and that was it. That was end of the story. But I have also heard, I mean, I'm quite careful about photos, especially as somebody who's done a lot of photography. So I tend to be err on the side of caution. But I have also heard of even some scams where they try to intimidate you into paying and things like that, and you haven't actually done anything wrong, or you may not have even used the photo. And so that's also important too, is just keeping a list of all the assets that you have licensed, so that you can go back and, like, if somebody says that photo with the red ball and the dog, you can see, first of all, did I actually use a photo with a red ball and a dog? And then find out where you used it and where you got it from. So
definitely. And also, at the same time, that's an excellent point, is to keep track of your IP and what you've licensed to others. So you have a clear list at any point.
Yeah, just in case you want to do a spot check.
Yes.
All right, so let's I was going to say, let's flip that around. What happens if somebody is using your stuff without permission? What can you do in that instance?
Good point. Same thing to start. Do your research. Have you licensed them that work before? If so, what are the terms and conditions of the license, and are they using it in that manner? And then you have to look at the site or wherever you see it and figure out if there is an owner, because a lot of websites that just pull content from all over, they're not that easy to tell who's behind it. Sometimes you even have to go to the internet company behind it. And then you have to decide what's important to you and if you want to pursue it by contacting them. It could be by phone, email, through a third party. And if you do and you don't hear back, what are you going to do? So how much time and resources you're going to put into that alleged infringement? And I hate to say, but you have to be practical.
No, you're absolutely right. I remember going to a lecture put on by a very well-known photographer here in Vancouver, and he got asked this question, like, how do you police when people are using your work without permission? And he said, unless it's Nike or Coca-Cola, he's like, I don't. He said, it's not worth my time. I would rather be creating something new than chasing down all these little infringements. Like, it's not worth it. It wasn't worth it to him personally to do that.
Yeah.
So that's a really good point that you make there.
Yeah. So a lot of it is just being practical.
So what are some simple things that we as creatives can do before needing to contact a lawyer, whether it's protecting our business and our intellectual property, or making sure that we're staying on the right side of things when we create new pieces or new products?
Okay, I think that a lot of the points we're going to talk about now are probably a summary of what we've been saying earlier in the podcast, which is, to start off, whenever you create a work, maybe you have a checklist. And even though copyright is automatic in Canada, you may choose to register in Canada or the US, maybe once a year, or maybe once when you have a certain product. And I think using a copyright notice, the C in the circle with the year of publication. So first time you're sharing it with the public and your name. And then even a longer notice and to say, this work is protected by copyright, and if you want to use it, please click here for permission, because that's all part of the education for the user or viewer of your site. So I think that's important. And it doesn't hurt once in a while to do some Google searches or reverse searches where you put an image in and see if it comes up anywhere. I've actually seen large portions of my book on Canadian copyright law at least once on a bogus site. And it was very hard to tell who owned the site and what they were doing with it. And in the end, I decided just to let it go because I didn't think it really took away from my book.
Right.
But I was a little shocked because that book wasn't available at the time in an electronic format. And I was thinking, where are they? Are they scanning it? What are they doing?
Very cheeky to take
a
book on copyright law.
I know. It was probably AI who took it before we talked about AI every minute. So that's important. And as Melissa said as well, to keep a list of licensed assets, both ones you license from others and your assets that you're licensing. So you always know what your rights are or what the terms and conditions are. And then just a tip, probably not answering that specific question, but whenever someone asks to use your intellectual property, ask for a fee. There's no reason why people should be using your work without a fee. You're a professional creator. You may be a business person. All your work is valuable, and you should think of it as valuable. What you charge, it's hard to say. You have to look at all the circumstances, what kind of use, whether it's a billboard or an illustration to go with an article in someone's website. But you can tell the person contacting you that there is a fee, or there's a fee. If you're shy to negotiate at first, say there is a fee negotiation, or there's a range between $200 and $500, and ask them a few questions, how they're going to use it, for how long, it is, maybe it'll just be up for a month, or maybe it'll be on their homepage, the big photo when you open that homepage. So you can see how different uses you may ask for varying fees.
Yes, I think that's really important. We create these bodies of work, and they are how we earn our living. And so it's important to value what you've created. It's what pays your bills.
Yeah. And to think of your creations as intellectual property.
Yeah.
I mean, it may not sound as fun, but it is important.
It is. And if you've been creating for a long time, you may have a very large body of work. You may not think about it because you just did it one piece at a time or one word at a time. But if you look back over 10 years, 20 years, 50, 60 years, and someone like Bob Dylan and his catalog, that's a big body of work.
Yeah. No, very true. I'll just add one other comment. When people say, well, how much should I charge for this work? When I was in law school in first year, my litigation professor said, you charge, not necessarily for IP, but in any lawsuit, you charge as much as you can without laughing out loud. Well, you're laughing out loud. And I always repeat that when I'm, talking to creators, because it's very hard to value your intellectual property. So
it's very true. And it just made me think of a question that came up when I was in school for graphic design, and we had to do the business side of being a graphic designer if you wanted to run your own business kind of thing, and what you should charge. And the advice was that if you give them a number and they say, okay, right away, without even pausing to think about it, you didn't charge enough.
Yes, I know. I hate that feeling. Even like at a garage sale when you're, getting something, it's like, oh, well, that was like too quick. I could have offered less.
Exactly. I did that last month. They sent a quote off to somebody, and I don't even know if they replied so quickly. I don't even think they read the quote, but it was just like, yes. And I was like, oh, damn.
Yeah.
I think I left money on the table there. So
that's funny. Yeah. And I think
like that. Laugh out loud. That's good.
Yeah. And you get more comfortable with it. And also, once you're pricing your IP, you can tell people, well, X company or maybe anonymous company paid $200 for this specific use, and then compare it. So you're not just picking a number out of the air.
Yes. That's good advice. Okay, let's get into because we're pushing the time here, but one of the things that comes up a lot, particularly today in the age of remixes and TikTok and collaborations, all these lines start to get really blurry when you're on platforms like TikTok, or when you work with another artist or creative. Like, how do you manage that?
Mm-hmm. No,
I know that's a huge question.
Tricky. Well, any collaborative project, you really should have an agreement with your co-collaborator, collaborators. That's really important. So it could be simple, like you create this, I create that. Royalties are divided 50-50, or whatever you agree to. But it's really important to have something in writing.
Yes.
Whether you do it yourself or you get a lawyer. Also, if you do belong to any creative associations, you could ask them if they have any sample collaboration agreements.
That's a good point. Particularly, I know, like, if you're a graphic designer, and where we have our own organizations and things, professional organizations, they'll often have resources like that for you.
Yeah, there's a lot of good stuff. Like RGD has a lot of good stuff.
So, and so then when you get into the whole, remix, sampling,
Yeah.
There was a really famous song, Bittersweet Symphony. This was years ago, back in the 90s, I think. And
Hmm.
I can't remember the name of the band, but they used something that sounded very much like a snippet from a Rolling Stone song, and the Stones took them to court, and they lost all the rights to any money that was made from that song.
Oh. Hmm.
And it was a very popular song, but they had sampled without getting permission. And so, but when you're dealing with something like TikTok or Instagram, like once you put it out there, it's really like you're opening a can of worms, and it really can get out of your control so quickly.
Yeah, it's hard. I mean, a lot of photographers, for instance, will only post low resolution
Mm-hmm.
photos online. So reusing them isn't always a great option. Watermarking, yeah, there's no great, great answers. And there is a lot of blurry lines.
Mm-hmm.
There's no like one rule I could say applies in all cases. Well, I shouldn't say that. One, maybe one way around it is if you are going to use someone else's work, and of course, this is not legal advice, make it as non-recognizable as you can. But, even within that, you don't know. And with the technology now, and how things can be picked up, whether it's music or video or any sort of work. Maybe it's me because I am a lawyer and I have, that sort of thinking and background. I rather avoid an issue than not.
Yeah, agreed.
I mean, I guess it's caution for all of us when we post, even though we don't want to think this way, but to think how it can be used on certain social media and used again and again.
Yeah, I think that's really important when we do post. I mean, I've heard people say this so many times. If you don't want it to be stolen, don't post it on the internet.
Which
Which,
is sad, but
is, yeah, it is sad, but there is some truth to it. And I think if anything, it just maybe take a moment to pause before you post something and just ask yourself, what happens if this goes viral and people start using it? Am I okay with that?
mm-hmm.
So okay.
Yeah, it's a tough one.
It is, and it's I don't even know how that would be policed, or like it can get away, it can take on a life of its own so quickly that I don't know how anybody would be able to. It's like somebody compared it to playing whack-a-mole, right? You
Yeah.
get one and then another one pops up, and
Yeah.
so
Yeah, it's true.
are there any red flags that we should watch out for, that we can watch out for on our own when it comes to our intellectual property, like signing those contracts, knowing what to look for in a contract, or
Yep, both of
those,
those. And always with a contract, almost never assign your rights, always
right?
license them. So
Yes.
again, an assignment is a transfer of rights. A license is mere permission to use your work.
Yeah, that is so
Um,
important. Like, I'm glad you mentioned it twice now, because understanding the difference between what a license is and assigning your rights is they're
And especially like for new creators,
Mhm.
it's easy to say, oh, they want to give me $100 for my, I don't know, photograph. This is amazing. I'm still in school. I'm going to assign them all my rights.
Yep.
No,
So many
don't.
of us have made that mistake, and you only have to make it
Absolutely.
once, and then you learn your lesson. But
Absolutely.
it can be so tempting and honestly, if they're willing to pay you $100 to buy the photo, they're probably willing to pay you $100 to license it. So
Yeah, they often only want a license, but
yeah,
they may not know any better themselves.
that's a
That's,
good point. A lot of
yeah.
times the person who's contacting you is not a lawyer. It might be somebody from their marketing department, and they just
Hmm.
say, we want to purchase this photo. They don't understand what they're necessarily asking. They may mean we just want to license it rather than purchase it. So
Right. And that's a tough issue too, is that as a creator, you may be in the position of educating your users or your market or licensees about copyright, then you're just maybe one step ahead of them. But again, if you have your own contract that clearly sets out it's a license, that can be very helpful.
Mm-hmm. So if you are somebody who does photography or creative services like graphic design, or even maybe as an illustrator, you don't think of this. I do a lot of illustration, but you might want to have those agreements, like a template agreement or a boilerplate agreement early on, because you never know. Somebody might want to use your illustration for a pattern design or fabric, or like there's so many, we don't even think of all the ways our work can be used when we start out. So
absolutely. So that's, again, why it's so important when you're young or starting a new business to learn more about copyright
mm-hmm.
and how it can help you, because it's really part of your creative and business strategy.
Mm-hmm. And this is, a lot of creatives are self-taught. We don't necessarily, there's so much information, and it's so easy to grow your skills and your craft through online learning without necessarily going to school for it or getting a fine arts degree or any of those things. But one of the things when you do go through school is very often you learn about this whole side of it, the licensing and the legal side of it. That's often something that you have to take in order to graduate. So
Mm-hmm.
you get a bit of a grounding in it before you even get out into the world. But if you're self-taught, you need to make sure that you are giving yourself a breadth of education in terms of what can happen with your work.
And to treat,
Just...
and to treat your work as a business.
Mm-hmm. Exactly.
And I think you've had other podcasts on that topic too.
Yes. So we try to cross the line between being creative and being an entrepreneur.
Yeah, which you definitely are.
So, big question. When should I call a lawyer?
Good question. It could be at different points. For instance, if you have a business where you're licensing your content to others, you may want to involve a lawyer to write you a one-page license agreement. Mm-hmm. That may be a good use of lawyers' time. Again, you may want to go to one of the artist legal advice services first, because they may be able to help you for free. I know they're in Toronto, Vancouver. I'm not sure what other cities. But maybe even if you're not in those cities, they can now help you online. I'm not following all their work. So that would be a preventative measure. And then if Nike is using your images, I'd call a lawyer.
Yes.
So it's kind of on the beginning end and on the wait a second, why are they using my work? And
I'm a big believer in sitting down with a lawyer as soon as you're in a position to afford it, just to get those sort of 2 or 3 pieces that you need in your business, like a licensing agreement, like a terms and services, or for your website, or a boilerplate contract if you provide services, creative services, just to make your life easier. In the long run.
It's as I've said earlier, it's not just a legal issue, but it's a business and strategic issue, and it could save you so much just so much aggravation, let's say, and money later on.
It is, and it's protecting the work that you create, which is what's, as we said before, paying your bills. So very important. Okay. Before we wrap up, I do have to ask you your thoughts on everything that's happening with AI, because it has just been such an uproar the last couple of months. There's been ChatGPT, there's been Lenza. And before we get into this, I do just want to say something about AI, because I've seen so many artists and creatives getting very upset about it, and in some cases with good reason. But I think it's really important for all of us creatives to understand that we've been using AI tools for years, and they're part of our daily workflow. If you use Photoshop, that has some very powerful AI capabilities. Canva has powerful AI capabilities. Even Google SEO uses AI to return your search engine results. So it's part of what we do, but now we're starting to see it. I guess people are seeing it as a threat at this point. There's been a couple of different ones. Lensa, I think it's called Lensa, was the app where people would pay to have their portrait generated, and so there was quite an uproar over that. And then you have ChatGPT, which is currently free. I don't think it's going to stay free, but and essentially those two tools work by taking other works and sort of almost amalgamating them. Like, that's how those tools learn, is by consuming other creations. And I think that's where people get very nervous. So what are your thoughts on everything that's been going on?
So good questions. So last week, my husband went on Chat GPT, and I forget exactly what he asked, but something like Lesley Ellen Harris's work in copyright. And then he read me what it came back with. And the beginning of it was like, oh, that's great. It's just like being scraped right off my website. And then there were other things that said, I mean, it's so intelligent and writes so well. I'm like, well, that part isn't from my website, but maybe it's like from another website, like when I spoke at a conference or something. So it just reinforced in my mind how exactly, or reinforced or brought up the question, how exactly it's generating the content it is. So there's definitely some scraping and reuse, and probably some more original thought. But I too find it a little scary in so many ways. I mean, one is, it's straight copyright. If it's not rewording anything in its own language, if it's just copying portions, then it probably needs it probably needs to get permissions. And then there's that whole other side, which is, if you create something through AI, is it protected by copyright? And that's also an unknown.
Yeah.
So I've been reading articles, several every week pop up on my feeds. And I don't, like anyone, I don't have any answers right now, but I do think it's important to think about both, if you're using AI to create work, to do your best to make sure it's not infringing others' copyright. And if you're creating works using AI, to put in as much human component as possible, if you want to protect that work. So even to use AI to create, I don't know, an outline for a course, just use that more as research rather than as your end result that you're using, and then consult other sources and use your own brain's AI and pull together something. So I know it's not the answer anyone wants, but right now it's more a question than any answers.
I think that's a very good point. I think it's not going anywhere. So I think we need to educate ourselves as much as we can about it and be very aware of what it can do and how to use it. I think burying our head in the sand is not really a good option, because it's
right.
It's
right.
not going anywhere. So one thing you said, I was experimenting with it. This is like a few weeks ago, maybe a month ago, I can't remember. And I was talking to a couple of girlfriends about it, and who happen to be bloggers, and they were asking what I thought, and I said, I feel like I'm in elementary school, when you would have to do a report on ancient Egypt, and you would go to the encyclopedias and you basically copy out what the encyclopedia wrote, because you're 8 and you don't know what plagiarism is.
Yes.
And that's essentially how it feels. Like, I feel like I'm getting the kids' encyclopedia version spewed back at me. Like, it's very simple, and it's it just feels very generic and there's no personality to it. But yeah, that's just what it made me think of, those elementary school reports that you had to write when you were in grade 4 or 5.
That's a good analogy.
So,
and the learning curve too, because you said how you don't know anything about plagiarism at that stage.
You don't know that stuff when you're 9, and your teachers will tell you don't copy it out of the encyclopedia, so you change a few words, right? But essentially it was copied out of Childcraft or World Encyclopedia.
No, good point. So I guess the bottom line is it's evolving, the whole copyright issue on both sides of AI, and just to know it's not straightforward whether you own and how it may infringe copyright.
It'll be really interesting to see where it goes in the next couple of years. I think what surprised people is that it has come to fruition much more quickly than anyone thought it would, and the level of sophistication is much higher than anybody expected it to be so soon. So it'll be very interesting to see what happens with it. But
I agree.
I think also tools like ChatGPT will become paid tools, and they'll probably be quite expensive. So whether or not everybody will have the same kind of access that they have today will remain to be seen. They've been very clear on their website that it's free right now. So that probably means that it will eventually become a paid tool. So
yeah, that makes sense. But there'll probably be a zillion more AI tools out there.
Google and Bing have both launched tools. I think Google's is called Bard, and I can't remember what Bing's is called. But there was even just something in the news yesterday or the day before that I was reading where a programmer was able to trick one of these tools. It might have been Bing. I'm not 100% sure on that, into giving up its some of its code. And then they asked the tool how it felt, and the tool came back saying that it felt violated, and so it was very interesting. It was
some emotion.
Yes, it made me think of Hal from 2001: A Space Odyssey. Started singing Daisy.
Yeah, that is funny. Yeah, some interesting times. Yeah, that's for sure.
Lesley, thank you so much for being here today. You've given us like a wealth of your knowledge here to chew on. Where can people find you online? Because I know you're in quite a few different places. So.
Yeah. Well, first of all, thank you. It's always my pleasure to chat with you as a person, not as AI.
No, it's been fun.
And to be able to share some of these practical tips with your, I was going to say viewers, I guess they're listeners. So again, my pleasure. Finding me, and I have a lot of articles written on copyright in plain English, is my website, copyrightlaws.com. Or you can Google my name. I'm being told I'm all over.
And you are also quite active on LinkedIn as well. So
follow me on LinkedIn.
Yeah.
I'm down to just basically one social media now. So that's the one of my choice.
It's a good one for what you do. So
yeah. And everything I do, like even when I post on LinkedIn, it's all on copyright and licensing for non-lawyers in plain English.
Yeah, she posts some great little snippets that are really easy to digest, and also you post some good questions to get people to think. So I always enjoy seeing what you post on LinkedIn. We will put links to all of that in the show notes. You also have some courses and programs that people can take if they want to learn more about copyright.
Yeah, and they're ongoing online, and with human interaction, not AI interaction. And they're fun. I'm very pleased to say in my evaluations when I teach, people say, oh, they're informative, they're this, they're that, and they're fun. So I take that as a high compliment.
It is. I think people always think that legal stuff has to be boring. It does not. So definitely Lesley's website is a wealth of resources. As I mentioned, I have one of her books that I have referred to on many occasions that I found very useful. And it's also excellent kind of, it's not dry or boring. It's just very excellent. Get to the point, answer the question. And I found it very useful. And as I said, I've known Lesley for a long time, and I have learned a tremendous amount about copyright and how it works and what to do and what not to do and where to be cautious from her. And I'm so glad that we were able to pass on some of your knowledge here to the audience. So thank you so much.
Yeah, well, thank you again for the opportunity, and it was nice chatting with you on any topic.
It's been fun. It's been a while since we've had an opportunity to chat, so I appreciate you being here. All right, everybody, thank you so much for listening this week, and we will be back soon with another brand new episode. Thank you so much for joining us for the And She Looked Up Creative Hour. If you're looking for links or resources mentioned in this episode, you can find detailed show notes on our website at andshелookedup.com. While you're there, be sure to sign up for our newsletter for more business tips, profiles of inspiring Canadian creative women, and so much more. If you enjoyed this episode, please be sure to subscribe to the show via your podcast app of choice so you never miss an episode. We always love to hear from you, so we'd love it if you'd leave us a review through iTunes or Apple Podcasts. Drop us a note via our website at andshелookedup.com, or come say hi on Instagram at andshелookedup. Thanks for listening, and we'll see you next week.